Are you an injured worker's attorney arguing for 100% disability for your client, or are you an injured worker arguing 100% disability? It's very important that you know exactly how to calculate 100% disability award, as a very small mistake on the start date of the PD could be the difference of hundreds of thousands of dollars of benefits. There's a recent case law that came down that sheds light. In this video, I'm going to explain when it should start and how significant it is with interest and cost of living adjustment. Hi. My name is Michael Burgis. I'm the managing attorney of Michael Burgis Associates. I'm a legal certified specialist in California workers' compensation, and I'm a trial attorney. I get a lot of calls regarding 100% workers' comp disability claims, and particularly how you calculate these. There's a great new case that just came down called San Mateo County Transit District v. WCAB that sheds light. In this video, I'm going to break it all down. First, let me go over the difference between a 99% case and under and a 100% case, because it's important on the foundation to understand the difference between the two. In a case between 0 and 69%, your compensation is paid out in permanent disability in finite weeks. The greater the disability, the greater the duration of those payments. But when that last payment of permanent disability ends, there is no more money. Now, if you're between 70 to 99%, again, the greater the disability, the longer the duration of those payments. But when they furnish the last permanent disability payment, when you're above 70, under 99, you get a life pension. Think of it as a small stipend that gradually increases over time with something called cost of living adjustment, basically to take into consideration interest and inflation, really. But the case law establishes that interest starts to raise and that cost of living starts to go up when they start furnishing that life pension, which is years down the line. Now, in a 100% case, it is a massive difference. It is not the permanent disability rate, which is typically $290. It's the temporary disability rate for life, which is 2/3 of an injured worker's salary, subject to a max and a min for the rest of their life. But when does the permanent disability kick in? When does that interest start to accrue? These are big, big differences and can equate to hundreds of thousands of dollars difference to an injured worker. So if you're an injured worker attorney and you're litigating a 100% case, there's huge pitfalls here. And this is one of the many pitfalls. But this is dangerous. This is where you can easily get caught up in malpractice because of a simple mathematical error in the calculation, which there's, again, now binding case law that sheds light on. Ultimately, typically for cases that are not 100%, the permanent disability starts when an injured worker reaches their point of what's called maximum medical improvement, or when they are permanent and stationary. That means with or without treatment over the next year, they're not going to get any better, right? Now, also, during a treatment phase, there's temporary disability. So if an injured worker can't work, they can get temporary disability. But on these catastrophic cases that are 100% disability cases, typically you see a catastrophic injury, you see a long period of temporary disability, but that temporary disability is generally capped at 104 weeks. So after 104 weeks, they don't pay any more temporary disability. And they don't have to start paying permanent disability because we don't know if the injured worker is going to have a full recovery or not. So then there's a period of time where there's really no money until there's medical reports stating that they're permanent and stationary and addressing that permanent disability. And again, in a case that's 99% or below, the date they reach that point of maximum medical improvement is when that disability starts. However, in a 100% disability case, this case now says the permanent disability starts not when they're at their point of maximum medical improvement. It's when the last payment of temporary disability made. So let me just put this into context for a second. You have a catastrophic injury, you're temporarily disabled for more than 2 years, multiple surgeries, they stop paying you at 104 weeks, and then there's a big gap, and then finally there's medical evidence indicating you're permanent and stationary years later. Ultimately, if that start of the permanent disability date is down the road, that interest starts later. This case says no. You go back to the last date of temporary disability. In this case, this can be 5 years, 10 years earlier. That means that permanent disability rate, which is 2/3 of their salary, starts at a much earlier date, and likely a massive retroactive award is going to be needed for that. But also that COLA, that cost of living adjustment, starts that January 1st after the start of the permanent disability payments. So again, this case is San Mateo County Transit District v. WCAB. It is right on point with what I've been arguing even before this case came out, but this case makes it conclusive and establishes, again, that the permanent disability doesn't start at MMI or PNS. It starts at the last furnishing of temporary disability. And guys, if you put this in mathematical terms, you're talking about hundreds of thousands of dollars to the injured worker, and tens of thousands, if not hundreds of thousands, in attorney fees. And if you mess up on this calculation, this is malpractice. I hope this video has been helpful. I've made many videos on 100% disability cases and how difficult it is to get to those and some of the pitfalls, but this is a pitfall that I wanted to highlight, and there's great case law directly on point. Hopefully this has been helpful. If you have any questions or concerns, my office is standing by. Please like, subscribe, as we put out lots of videos that shed light on the plight of California injured workers and recent case law.